Welcome to the module on Management of Voluntary Organization. The learning objectives of this module are to understand the basic difference between the service organizations and other organizations like government, commercial and private organizations, to know how a service organization works, how a person can give back something to the society from where he or she has enriched himself or herself through the means of an established structure. Certain historical background and development of different type of service organization, how the concept of non-governmental organization came about, the origin, types and legal requirements of establishing a service organization, especially in India, which henceforth referred to as NGO. Let us look into the key aspects of non-government organization. A non-governmental organization is a popular terminology used in India to refer to a charitable, philanthropic, service-oriented, not-for-profit and not-profit organization. Each of these terms have their own nuances, but in most cases they are used as synonymous words. The term non-government organization or NGO came into use in 1945 because of the need for the UN to differentiate in its charter between participation rights for intergovernmental specialized agencies and those for international private organization. At the UN, virtually all types of private bodies can be recognized as NGOs. They only have to be independent from government controls, not seeking to challenge government either as a political party or by a narrow focus on human rights, non-profit making and non-criminal. A human society has different human, social and administrative functions. It is a network of persons and activities. Given contemporary multifaceted social life, we can see how we are invariably connected, beginning from a human person to a government, which can be seen in the following diagram. The history and origin of NGOs. The origins of NGOs are from time immemorial. Some of the charitable activities are as old as human nature itself. Basic human nature did reach out to the needy, though not in an organized and formal way. Early society had a mixture of religion and charity. This is clear from many religious practices and observances. In line with today's governmental structure, the kings, princes and rulers did reach out to the needy and suffering. At the same time, many religious centers too attended to the general public, which consisted mainly of pilgrims. From the 4th century BC to 5th century AD, especially during the reign of the Maurya and Gupta, a strong village community based on collective entrepreneurship and social collectiveness was in existence across the country. These practices of philanthropy, together with a strong and collective community life, have been transformed into a modern concept of social responsibility. Moreover, every religion preaches charity, almsgiving, feeding the poor and reaching out to the needy. This social consciousness was closely knit with religious belief of appeasing God and meriting for oneself moksha, bliss, heaven or salvation. According to Nabi, non-governmental organization, NGOs, play an important role in the development of a society. They endeavor to make good living condition for the neglected, the underprivileged and the destitute people. Ours is a socialist country and our government emphasizes the upliftment of the downtrodden and vulnerable section of society. However, without proper implementing agencies working at the grassroots, all budgetary allocations, government grant in aid schemes will go down the drain. It is the NGOs who execute the various government programs and thus play a significant role in achieving the socialist objective of our constitution. It is because of NGOs that we see a more civilized society. The figure on the screen will show at least 4 major player sections in a welfare state concept. The definitions. An NGO is a legally constituted non-government entity incorporated under state or central laws as charitable or non-profit organization that has been set up to serve some public purposes and enjoys certain tax exemption under tax laws. A non-profit corporation or an NGO is usually created with a specific purpose, such as for education, charitable or related to other enumerated purposes, may be a foundation, a charity or other type of non-profit organization. In some cases, it may also be a public corporation. In many countries, these entities are subject to exemption from various tax laws with certain restrictions. NGOs is a concept difficult to define, and hence many authors prefer to enumerate the certain salient features. Some of the salient features are voluntary in nature, organized structure and activity, not for profit motive, not a government agency, though at times might collaborate with government organizations. Let us look into the legal provision of NGOs. A NGO works in a society and for one or more needs of the society. Society is a web of relations guided by certain rules and customs. To an extent, a NGO functions within the context of a society. There ought to be certain rules and regulations. Therefore, everywhere in the world there are specific legal provisions for NGOs. There are NGOs who work within a country, geographical boundaries, and there are some other NGOs which reach out beyond national frontiers. We call them international NGOs. Legal framework for an NGO in India. NGOs can be formed in multiple ways in India and will be subject to various acts of legislation. The right of all citizens to form associations or unions is guaranteed by our Indian Constitution, Article 19(1)(c). Charities and charitable institutions, charitable and religious endowments and religious institutions is a subject in the concurrent list of the 7th schedule of the Constitution of India, which means both the center and the state are competent to legislate and regulate NGO organizations or service organizations. Under Schedule 7 of the Indian Constitution, the words trust and trustees find mention at entry number 10 in the concurrent list, and charities and charitable institutions. Charitable and religious endowments and religious institutions find place at entry number 28 of this list. The 3 main areas that need our attention is trust, registered societies and section 25 companies. A non-profit organization, which is generally called a non-government organization, can be registered in India as a registered society under the Registrar of Societies or as a trust by making and registering a trust deed. A third option is registration as a section 25 company under the Companies Act of 1956. There is no comprehensive central law for legal incorporation of NGO organization which applies to trust, registered societies and Section 25 companies alike. For promoting commerce, art, science, sports, education, research, social welfare, religion, charity, protection of environment or any other object, provided the profits, if any, or other income is applied for promoting only the objects of the company and no dividend is paid to its members. Whether a trust, society or company, as per above mentioned sections, the Income Tax Act of 1961 gives all categories equal treatment in terms of exempting their income and granting ATG certificates. Those organizations which enjoy the said ATG benefit or exemption avail the possibility of offering partial rebate to donors of such organization. In addition, there is a law for all foreign contribution to non-government organizations. It is governed by the Foreign Contribution Regulation Act 2010 and been monitored by the Home Ministry. NGO organizations here in India enjoy a great deal of independence from state or government monitoring. Most of them are self-governed by an administrative or executive board which may be called by different names. All these members are expected to function as trustees, caretakers without deriving any benefit for themselves or to their relatives, but only for the general public or a section of the public. To this extent, it will be known and recognized as charitable or not-for-profit organization. Commencement of an NGO. There are noble persons in society who have an altruistic spirit and magnanimous heart. The presence of such people in every age or every society gives rise to many an organization to alleviate some form of human suffering or to offer other services. According to Bruce R. Hopkins, an NGO or non-profit organization, particularly a charitable one, supports a realization of the institution's mission and encourages volunteerism. Society benefits not only from the application of private wealth to specific public purposes, but also from the variety of programs that individual philanthropists make available. An illustration would make it easy to understand why and how some people initiate an organization which would be called an NGO. What are the problems faced by society? What are the solutions for these problems? How many resources are required? Whether indirect intervention by the government is ideal, whether involvement of the whole society is beneficial, do we have an other solution or an option, whether certain individuals or organizations are interested in addressing this problem, what type of organization is better suited to take care of this need, whether private, public, individual association, corporate body or semi-government corporations. Does the problem need time for solution, an epidemic, or require perpetual attendance, for example, like education of children? These points are also some motivating factors which spur many to act either individual or collectively. Once the effort is made to act collectively and to get registered under one or other legal provisions stated earlier, we are able to identify that an NGO has been formed. Trust. In India, trust is one of the most commonly used legal frameworks to establish an NGO. Understanding the background of a trust and the history of its legal framework enables us appreciate the system of NGOs. Trusts are created for fulfillment of certain obligations, either of charitable or religious nature or of personal nature. A trust is the confidence reposed in certain persons who are entrusted with the requisite powers and responsibilities to fulfill the objects specified by the author or settler or the trust. The concept of trust flows from the faith of one person in the honesty, integrity and reliability to another person. If a person out of free will entrusts his property to the care of another person for a specific purpose or period, the other person has to uphold the trust reposed in him. His obligation include the protection of rightful ownership in the property, the preservation of the property in as good a condition as practicable, channelizing the income from the property in accordance with the intentions of the owner and taking all steps to safeguard the property and the interest therein. The functions of a trust are administered by the instrument of trust and the laws governing trust. Society. The word society refers to another form of NGO constituted in India. The registered societies are modelled on the English Literary and Scientific Institutions Act of 1854. The Societies Registration Act was enacted in India in 1860 towards the middle of the 19th century, coinciding with the 1857 event. A number of organizations and groups were established in the country on contemporary issues of politics, literature, arts and science. Till 1947, this act did not undergo any major change. Registration remained largely a voluntary effort. After independence, as a consequence of the adaptation orders 1948-1950, the act remained on the statute, but societies being a subject under the state list, it came under the legislative competence of state governments. Let us try to understand the concept of registered society. An NGO may be formed as a society. As per the Societies Registration Act 1860, a society can be formed by minimum 7 or more persons eligible to enter into a contract for any purposes that in the eyes of a law pertain to public good. When an NGO is constituted as a society, it requires to be registered under the Societies Registration Act. This is done after the Memorandum of Association and the rules and regulations of the society which have been drafted, signed and witnessed in the prescribed manner by the 7 or more members, and a registration certificate is obtained. This has been the law and practice since the beginning of the legislation, which is more than 1.5 century old. A company under section 25. A company under section 25 of the Companies Act 1956 is another option to create an NGO in India. These companies are generally formed for the sole purpose of promoting commerce, art, science, religion, charity or any other useful object and have been granted a license by the central government recognizing them as such. Administration of an NGO. The historical and legal background of NGOs logically leads to explore the way they function. A NGO once established functions like a corporate body or a legal person or an artificial judicial person distinct from a natural human person. Its administrative activities will have to be carried on by a human person on and behalf of the NGO. In practice, this role is fulfilled by a team of persons who are called a board of trustees or other names. An NGO board may be called by different names, that is board of director, steering committee, executive team, governing council, administrative body, advisory group, etc. The term board is used collectively and interchangeable to mean all these names. How does an NGO board function? What does it do? It first sets policies and strategies for the NGO in line with the agreed purposes, principles and scope of the NGO. It also sets operational guidelines, works plans and budgets for the NGOs and policy and program support. Many times it is also called upon to make funding decisions. It assists the internal workings of the NGOs by setting criteria for membership of and appointing review panels and or support groups. It may also establish a framework for monitoring and periodic independent evaluation of performance and financial accountability of activities supported by the NGO. In reference to the board in an NGO or its functionaries, primary attention must be given to the type of members an NGO can have. Generally, the members may be classified as founding members, full or regular members, affiliate members, honorary members, members with voting rights or without voting rights, student members. Depending on the internal functioning and its proper rules and regulations, some members will be either appointed or elected as governing body members. These office bearers are generally called President, Vice President, General Secretary, Treasurer, Joint Secretary, Executive Committee members. Closure and termination of an NGO. The NGO can be terminated for various reasons. A NGO might have been set up for a particular need, and when such need has been attended to, the need of that NGO ceases. Intentions of the founding members, completion of a project, lack of resources, bankruptcy and government intervention. The NGO which enjoyed tax exemption and other benefits will have to follow strictly the legal requirements. Dissolution must be approved by at least 3/5 of the society's member. Upon dissolution and after settlement of all the debts and liabilities, the funds and property of the society may not be distributed among the members of the society. Rather, the remaining funds and property must be given or transferred to some other society, preferably one with similar objects as the dissolved entity. Advantages of an NGO. The role NGOs play in society can be immense, far-reaching. Since it is a voluntary sector, it often draws very qualified and talented persons as members. Tax exemption, tax benefit, tax rebate and other tax related matters make many in society either contribute or get involved in one or other noble activity of public utility. An NGO offers a possibility to work for the common good. Hence, the benefit can be emotional, personal, mental, physical and spiritual in nature. Challenges. A good deal of NGO functioning is left to their own articles of incorporation and bylaws and not to the government or to the public. This autonomy can very well be misused by unscrupulous NGOs. The tax exemption also can be misused by some NGOs. The accountability of the administrator as to their role and or trusteeship is also another sphere which needs continuous monitoring. The volume of the court litigation pertaining to trustees and trust property are only an indication how this aspect of individual accountability is at stake. An NGO often outlives its founding members, volunteers and noble board members. In the course of time, the new office bearers and functionaries may not have the same type of zeal and zest to carry on the noble ideals of the founding members. This results in a slow death of the very purpose of an NGO which was established. A non-profit sector may become profit making or under the delusion of not making profit. The employees of the NGOs might lose hope as to the fruitfulness of their work or the general public. Many NGOs involved in advocacy will not be able to quantify their contribution in arithmetic terms. This would be difficult for the general public to assess the contribution of an NGO as well as a challenge to the NGO itself to prove its contribution tangibly. Networking and internal communication is another set of challenges NGOs face. Staff members don't willingly speak on critical problems and feel disconnected from important decision making. Often board members and administrators do not create an operational policy that outlines procedures for involving staff and everyone. Finally, public visibility is also a challenge. The public name, the role of PROs, the reputation of board members, the past reach out programs in society, the ideal and universal goals and purposes, all this contribute to the external relations. If there is a confusion in the minds of public regarding any aspect of an NGO, this will hamper growth and public support. Summing up the module, in this module, the learner got an opportunity to understand non-government organization and its salient features. The module also provided the history and origin of non-government organizations in India. Module also gave an overview of legal framework of non-government organizations, processes of starting an NGO and administration of NGO. Not only initiating a new NGO, but also the possibilities of terminating the same was another area that was considered. For a comprehensive understanding, the advantages, limitations and challenges of NGOs were enumerated. Thank you for attending this session.